does the state have anything they want to specifically address on the record this afternoon?
Your Honor, the only thing that I want to address is I do anticipate filing an amended information. I have, for a long time, been very clear that if this proceeded to trial, that I would file charges of intimidation based on the calls that were made on particular days. And so I anticipate having a total of 6 charges for intimidation of a victim in the amended information. I will get that filed as soon as possible, but I have explained that both to Attorney Jones. I've explained that to previous counsel numerous times in communications on this case. I don't think that's a surprise to anybody. I think on the charge in the underlying domestic violence case, we are going to be proceeding on amended charge of first-degree recklessly endangering safety rather than second-degree recklessly endangering safety.
20 minutes later.
Plea paperwork, and I understand that the parties have reached an agreement. Mr. Torbenson, do you want to put the state's offer on the record?
Case ending 4596, the state anticipates Mr. Brooks entering a no contest plea to count 3, second-degree recklessly endangering safety as an act of domestic abuse. Based upon that plea to count 3, the remaining charges will be dismissed and read in for consideration at sentencing. As to case ending 5020, the state anticipates Mr. Brooks entering a plea of no contest to count 1, felony intimidation of a victim. Based upon that plea, the state would move the court to dismiss and read in the remaining 2 charges for consideration of sentencing. At the time of sentencing, the state will recommend that the court sentence Mr. Brooks to a substantial term in the Wisconsin state prison system. We would leave the ultimate interpretation of that to the sound discretion of the court. The defense would be completely free to argue for the appropriate sentence.
You're going to jail. You're going to jail.